I want to thank everybody for joining me today so we can talk about Medicare benefits and protecting those for your clients. So we should be about, I think it's about 45 minutes we'll go through, and then we should have some time for some questions too. It can get pretty complicated depending on the details of the case. And if for some reason you don't have time today to get into your questions, you can always reach out to me, and my information will be at the end of the presentation. So today, really what we're going to talk about is, as you're putting together your settlements, how do you protect the Medicare benefits for your client long-term? How do you comply with the MSP statute in terms of past and future medicals? So we're going to go through those today. Primarily what I'm working on has been the liability arena. And I know there is a lot of confusion out there as far as what do you have to do? What should you do? Where do you need to be concerned? Where do you not need to be concerned? Do you do an MSA? Do you not do one? So I'm going to try and clear some of that up today and give you a bunch of different options. I'm not here to push anything on you today. I'm here to just kind of educate you on the process and what to look out for. So with that, real quick, as far as me personally, I've been in the MSP compliance industry since 2005. I've done about 7,000 MSAs personally in that time, both in comp and liability. I've been with Medivest since 2007, so I've been here a long time. Little history on Medivest. This is the only commercial we really have here. We were founded in 1996. Our big focus is on Medicare secondary payer compliance, and we were the first company to professionally administer a Medicare set-aside allocation all the way back in 1998. So we do offer professional administration of MSA and non-MSA funds. We offer Medicare set-asides for comp and liability. We do Social Security and Medicare verifications. We do lien investigations and we have lien resolution services. So whether it's a Medicare, Medicaid, third-party lien, those are all things we can assist you with. We do medical cost projections. So if there's not a Medicare component to it and you're looking at a case valuation. Trust advisor services. So if there's a Medicaid component to the case as well, we can assist you with that. And then we also do medical custodial accounts. So that's my quick commercial. And then we'll go ahead and get into what we're talking about today. So when you hear about this, everybody talks about the Medicare secondary payer statute. And what that statute says is that if there is a primary party involved and they are responsible for paying prior to Medicare, Medicare cannot make that payment. So basically what it says is if you receive funds from a settlement or if there is a primary payer involved, Medicare is considered the secondary payer, and they are not permitted to make payment on those cases. They do on occasion pay for things they shouldn't pay for, and that's when you get into the lien situation, which we'll talk about in a little bit. So the Medicare secondary payer statute, in essence, says that you cannot shift the burden to Medicare. So as an example, in a work comp case, you may have somebody who settles their case, and 20 years ago, someone would settle their case. It would include treatment for future medical. And then what would happen is, instead of that money as part of that settlement for their future medical benefits and using it for their treatment, they would take their settlement funds, spend them how they saw fit, and then put down their Medicare card for treatment. So what was happening is they were shifting the burden to Medicare. And this went on, this came out in 1980. They basically ignored this. The government didn't even enforce this for about 20 years. So what happened was, you had all these individuals running expenses through Medicare, even when the statute was on the books that says you can't do that. Once they figured that out, they started looking into this and actively pursuing things related to it. So in terms of the types of insurance plans that are deemed primary by Medicare, they are workers' compensation, no-fault insurance, automobile insurance, liability insurance, and self-insured plans. So if one of these plans is providing for future medical treatment on a case, and they are paying for those items, Medicare can't reasonably be expected to make that payment because there is a primary payer involved. So here's one of the big things. There's a lot of confusion about how you address this issue in a liability settlement. So I would like to state, people always ask me, are MSAs required to comply with this statute? And the answer is no. They're not required. What is required is you consider Medicare's interest in the case from a past and future medical standpoint. So when we're talking past medicals, we're talking Medicare liens on the case. There are fines and penalties associated with the Medicare liens. I'm sure everybody's seen those liens from Medicare. So that's dealing with the past medicals. In terms of the future medicals, you have to make sure that you're not shifting the future medical responsibility to Medicare if there's a primary plan involved, including like a liability settlement. So complying with the statute is mandatory. Doing a Medicare set-aside is not a required process. You do have to do something. The reason you hear MSAs referenced frequently in terms of MSP compliance is because it's one of the few things that Medicare has weighed in on and says, this is a way to cover our interests from a future medical standpoint. And there's some benefits to making sure you cover those interests. So one of the big memos that came out, this was all the way back in 2011, is the Stall Cup memo. So the law requires that the Medicare trust funds be protected from payment for future services, whether it's work comp or liability. There's no distinction in the law. You consistently hear about this being a work comp issue. It applies to liability as well. There's no distinction in the law between the two. So even though there is no formal review process in place in the liability arena, like there is for work comp, Medicare does, CMS or Medicare does expect that the funds should be exhausted on otherwise Medicare covered expenses and otherwise reimbursable services related to what is claimed and or released before Medicare is ever billed. So they're expecting you to use any money that is for future medical treatment that is normally Medicare covered and would normally be paid for by Medicare. You need to use the settlement funds to pay for those items before Medicare is ever billed. And again, this is from the Stall Cup memo back in 2011. She indicated each attorney is going to have to decide based on the specific facts of each of their cases whether or not there is funding for future medicals, and if so, a need to protect the trust funds. So again, why is Medicare interested in your settlement? Medicare wants to make sure it's not paying the bill for items when there's a primary payer or primary plan involved on the case. Medicare wants to make sure that the burden is not being shifted to it by any of the parties involved in the settlement. And they want to make sure that if they have paid for any items that are covered under a primary plan, that they are reimbursed for those items. So making sure that liens are paid back is a big one. It has fines and penalties associated with it. You don't consider that. We're kind of going to shift here, and we're going to talk a little bit about covering the future medical piece of this and what can and can't happen if you don't plan for those items. So this is another big one. The question is, how is Medicare going to find out about my case? Before they started really monitoring these cases, they relied on the parties involved in the settlement to notify them when there was a Medicare beneficiary and they had a case that was settling. So what happened is they were just, requesting that people notify them when these settlements happen. What they realized is a lot of settlements were happening and nobody was notifying them, nobody was checking the liens. Medicare was paying out a lot of money on things they shouldn't have been paying out on. So right before Bush left office, he signed the Medicare S-chip, the Medicare and Medicaid S-chip Extension Act, also called the MMSCA. It's also commonly referred to as mandatory reporting. So effective July 1st, 2009, the Medicare and Medicaid S-chip Extension Act required that applicable plans, which are those plans I referenced earlier, those 5 plans, must first determine whether a claimant or plaintiff or applicant is a Medicare beneficiary, and then that primary payer must report the required information once the case is resolved to the Secretary of the Department of Health and Human Services in the form, manner, and frequency in which it prescribes. So basically, what Medicare is doing there is, hang on, looks like my slides are getting a little crazy on me here. Sorry about that. So what that's doing is it's saying we initially were relying on everybody to notify us about this, and nobody's doing it. So now we're going to require that. So when it says the primary payer, it's talking about the source of the funds. So if it's an insurance carrier, if it's a work comp carrier, it's a self-insured plan. If they are paying out money for a settlement on a Medicare beneficiary, they have to report all these data fields. Right now, it's over 200 data fields that have to be reported to Medicare. If they do not report those, it's quarterly reporting. If they do not report those settlements when they happen in the appropriate quarter, Medicare Medicare can go ahead and Medicare can actually stop payment for those items, and they can fine those primary payers up to $1,000 per day per claim. So, Mary, are you on still?
Looks like we're being bombed or something.
Yeah, I'm seeing that too. Sorry, everybody. I'm not sure what that is.
I don't know either.
Yeah.
Oh, wow. It's the lost soul of Dan Gordon.
Yeah, I don't know who Dan Gordon is, but I'll probably look him up here in a little while. But I'm just going to keep mowing through this.
Yeah, I'm going to go look through and see, if I don't recognize your name, I'm going to bump you off and then you can email me. But you go ahead.
Okay.
Because I have a lot of unknown phones here.
The show must go on, right?
Yes.
All right. So if the information is not provided to Medicare in the form, manner, and frequency requested, Medicare may impose a fine of up to $1,000 per day per claim. That is not something the plaintiff or the applicant is responsible for. That's a fine that would be paid by the primary payer. The reason that's important is since they put this program in place, they are now requiring these primary payers to notify them. So that is how they're going to find out about your settlement. They're required to report it by law. So what happens is it's all the attorney's information on the case, the nature of the injury, accident date, personal identification information, social security numbers, ICD-9, ICD-10 codes related to the case. They're going to be tracking all this stuff. And the reason that's important is if they get that information, then what they do with it is they flag it in their system. So in the future, if they ever get a bill associated with one of those ICD-9, ICD-10 codes, they know they're not primary. They know they're not supposed to pay it. So their primary enforcement mechanism post-settlement to make sure that they're not paying